That's a really good question, and a lot of people, I get that call a lot. When when the judge orders a reunification plan, sometimes the judge orders that you just do the plan, but sometimes the judge orders that you do the plan with the court approved or CPS approved reunification service vendor. Now, are we ready to take another call?
We are. We have Johnny from California. Johnny, do you have a question to ask or a story to tell?
I got a little bit of both, Mr. Vincent. Good evening.
Good evening.
Yeah, I just want to ask a question. Currently, I have a case plan that I'm trying to follow everything that the, Department Social Service DSS require me to do. But however, they're giving me more hard time as they asked me to do a risk assessment, which I want to do from outside vendor by my own, and they are not honoring that. So, and I talked to my attorney many times about this. So because I do not want them to manipulate and say something untrue about me. So how should I go about this?
That's a really good question, and a lot of people, I get that call a lot. When the judge orders a reunification plan, sometimes the judge orders that you just do the plan, but sometimes the judge orders that you do the plan with the court approved or CPS approved reunification service vendor. And, a lot of counties, especially in California, and you're from California, I see, require you to use one of their people. When that hasn't been ordered by the court at the disposition hearing, what I try to do is I walk on the case and try to get permission to use, this vendor instead of using the CPS vendor. And, frankly, I tell them, I tell the judge, this is the reason why. We're scared that that vendor that CPS has picked is aligned with that vendor and might say something that's not true for various reasons. And if the judge denies it, you're stuck with doing that, using the CPS vendor. But a lot of times what I will also recommend is, you use your CPS approved vendor and you also use your own vendor, but make sure that that vendor is qualified. So for example,
Yes,
if you're doing a risk assessment, you might they're going to send you to a social worker probably or a psychologist to do that assessment. Well, you should go out and find your own as well to make sure that that person is they're finding the same things. It's like having a drug test. When you do the drug test for CPS, it might come back positive, but when you request or you do another drug test on the same day and it comes back negative, well, there's an issue there.
Yeah, that's exactly what happened, Mr. Vincent. I did my DVI assessment and the recommendation from DVI, right, from what the DSS told me to do with their vendors. And what happened? There's a discrepancy. They asked me to go for more classes, and over here when I do in outside vendor, they say, no, you don't need any classes. But if you want, you're most welcome to do 8 hours, just to learn the system. And I told them there's a discrepancy, and I got my certificate, and I passed the test, with colorful marks. So I say, this is the reason I'm scared to do with your department. And this is not because I say you're trying to manipulate and not telling the truth, to the vendor and try to tell them something. And I also want to ask this very important question. When they submit something to the vendor, right, they say they want to submit some document about our case in the dependency, right? They have to get the judge, permission to release the record. And most of the time, I told them, okay, I'm fine with that, but I also need to review that record, and I also want to submit my story, and my document must be attested and must be reviewed by my attorney. And they did not reply. Whenever I asked that, they just keep quiet, And I filed an objection, I think JV 577, I believe, and I put that, I said, I have no issue with the DSS to release the record to the place that I need to go, but at the same time, I need to see that what they send to that vendor so that I can attest it, my document to show that this is not correct, this is what happened, so they can have clarity what really happened. And always when I come to that, they keep their mouth shut and do not want to talk about it and postpone or anything. So how I could handle that?
It's a strategy you're going to have to develop with your attorney. But, other than doing both or filing an 827 petition to disclose records to your own expert, there's not much that you can do. But you might want to talk to your attorney about filing the 827 petition to disclose confidential juvenile records to your own expert.
To my own expert?
Mm-hmm.
Yeah, I told them about that. I say I need to see the record. What is it all about? So I can have things to review what they submitted. They say they just want submitted what the allegation. See, because I did not get a proper trial during contested hearing. I did not get the chance to call the witness. So I wrote a letter to right now to my case is in appeal process. And I'm trying to tell the judge what a dependency court done to me is not right. And this has been happening all the time for since 2016.
Well, wait a
I
minute.
was in different place.
Wait a minute. Writing the judge is not going to do you any good. What you need to do is write your appellate attorney and have your appellate attorney explore this issue. Because, I don't know if there was, but there may have been what they call ineffective assistance of counsel that the appellate attorney might be able to argue if you felt that your trial wasn't fair. Now, I wasn't there, so I don't know if it was fair or not, but it's something that your appellate attorney can explore on appeal.
Yeah, he always want to tell basically what is social worker department story. But I now tell them is the attorney is ineffective counsel. They misrepresent. They're not even competent to tell my side of story.
Right, but you need to discuss that with the appellate attorney. I told a previous caller, I appreciate and respect your feelings about the competency of a lawyer. All right. But that doesn't mean under the law that you are correct. Right. Your feelings are one thing. The law is something else. That's why I'm saying you should talk to your appellate attorney about this to make sure that
I
that
talked to him many times.
Okay. And
I talked to him many times, and he always say,
2 minutes.
argue about this matter because this matter was not bring up during the in the trial. I say the reason why it's not bring up to the trial because the court-appointed attorney didn't do the work correctly. I was not represented properly. So how I'm going to bring up this matter? I only can raise my hand in the court, but the judge will never pay attention to me at all. And my court-appointed attorney supposed to talk on behalf of me, and we even cannot say objection because they mute our mic. So we during testified we only have very, very limited time to speak. So we cannot tell the judge what really happened.
Did you get to testify?
What?
Did you get to testify at your contested hearing?
I did not get a proper, they only allowed me to speak, testify very short time. Then I say I want to continue because they put a break. But I told them I need to tell more, but that's never happened. And one thing I want to ask you, Mr. Vincent, this is a very important question.
1 minute.
If we disapprove, right? We disapprove during somebody make allegation. I cannot stop anyone from making allegation, right? Anyone can make allegation. But when we prove the allegation was not substantiated, we are not that place, and we proven to the judge, then the judge always say, maybe, my story until now is only maybe on speculation, oh, maybe this thing happened. And when I prove to them this incident cannot happen like this because I'm in a different place, different city, there's no possibility I can be there. Then they will say this is about the person who making allegation, their credibility. I attack on their credibility. But always they say, children say, and children can be alienated very easy.
Wait, Johnny, what was the one more question you had?
Okay, right now.
No. Don't tell me the story because we're running out of time. Just ask me the question.
Okay, I comply with all the case plan. I have a positive visitation with my children, everything good. But I want to ask one important question. My child suffered serious injuries under the care of county. This is 3 consecutive times. The child suffered serious injuries under the care of the county. Not even one time in the social worker report been mentioning about this.
Johnny, you got to ask me the question, my friend, because my engineer is telling me we got to go to commercial break. Do you have a quick question?
Yeah, that is the question. Why they are not mentioning that in their report?
Well, I can't tell you. I've never talked to them, but they should. If your child's been injured while in foster care, definitely the court is supposed to be notified. I've had this come up before where social workers haven't notified the judge in a report that there was problems at the foster home, and I can only speculate why they do that. Maybe they just don't, they're trying to keep the judge in the dark. A lot of times I read the report and, in many cases it seems though that the social worker is giving, a version of her story or his story that supports her position. And a lot of times I think the judges, no judge has ever told me this, but I get the impression that they think the social worker's telling the truth and telling them everything. And that's not necessarily true. Hey, Johnny, I want to thank you for calling. Thank you for listening. Call us back in a few weeks. Let us know what's going on in your case. This is The Secret, How to Fight Child Protective Services and Win. We'll be right back after these messages.